Start recording. Here we go. Like I said, my name is Dixie Newnam. I am with Newnam Land here in Wimberley, and today we're going to be going over some will basics. This is the first of a 5-part series that I'm going to be doing with the library. The next couple will have to do with trusts, with beneficiary designations, with powers of attorney, and then probates. So each of those topics we'll hit on a little bit today, but we will be doing a more in-depth dive into those in coming weeks. So my goal is right now to do about one a month. We do not have the next one scheduled yet. As soon as it is scheduled, though, the library will send out information on it to participants. So just keep your eyes open for the the emails that are sent out by the library regarding their various activities, and hopefully that'll show up here soon. So like I said, I'm aiming for the end of October for the next one, and to do about one a month going forward. So we will just dive right in here, and I have a PowerPoint that I'm going to use because I know that when I'm talking about or learning about new materials, having something visual is often helpful to get a better idea of what may be going on. So this is what we're going to cover today, is again the basics of wills. And there are 4 basic things we're going to go over. We're going to go over what wills do and don't do. We're going to go over some basic provisions that are in most wills or should be in all wills. We're going to go over the dangers of outdated wills or do-it-yourself wills. And then finally, we'll talk about why everyone really needs a will in the first place. So let's start with the do's and don'ts. I think most people have a good understanding of generally what a will is. So what it does, it generally governs who gets your estate. Now, what a will does not do is it does not govern who gets all of your assets. So you're probably initially asking yourself, well, what is the difference between my estate and all of my assets? So your estate is a smaller portion of your assets. Those are the assets that actually funnel through your will. So if there are assets that funnel through your will, that means there are assets that also pass outside of your will. So what do I mean by that? When you draft your will, typically you'll have something that says, you know, everything to my spouse, and then to my children, or to my children, or to my loved ones. And so any asset that goes through your will be distributed according to their terms. However, there are assets that don't go through your will. So for an example, you may own real property with another individual that has either rights of survivorship or joint tenancy, or sometimes this is called tenancy in the entirety. When you own a piece of property, and here I'm talking about real property, so think land, house, something like that. When you own it either in joint tenancy or with right of survival or with tenancy in entirety, when you pass, your ownership interest goes to the other owner. Your ownership interest does not pass to your heirs. Now, a lot of the participants are probably listening to this from the state of Texas, and you do not see right of survivorship very often in Texas because of the community property laws. However, you do see it associated with real property in other states. And so if you own property maybe with a friend or maybe a child in another state, there is a possibility that you own it as joint tenancy. And upon your passing, your interest would go to that other person and not go according to the terms of your will. Another example of this, and you do see this more often in the state of Texas, is right of survivorship on bank accounts. So oftentimes people will set up a bank account and then they will add someone to it as they age. So they may add a son or a daughter to their account as they age so that son or daughter can help them manage their affairs. When you're setting up the bank account, banks will ask you, do you want right of survivorship, or do you want this joint? And so I think a lot of people think just automatically, yes, I want it joint. I want my son or daughter on there to help me. But when you add that extra language, the right of survivorship language to it, what that means is whoever you've added to the account with you will get whatever is in that account upon your passing, regardless of what's in your will. So let's go back to that example where you add maybe your son or your daughter to the bank account with you. And let's say you check right of survivorship, not really understanding the impact of that. But let's say you have 4 children in this scenario. So on one hand, you have this bank account with right of survivorship with 1 child who's helping you manage your affairs. And on the other hand, you have a will that says, upon my passing, everything will be evenly divided to my 4 children. What happens is anything in that bank account goes to the 1 child who's on that bank account with you because of that right of survivorship language. The other 3 don't get anything. It doesn't matter what your will says. So as a practical standpoint, I've actually seen this play out with wills where they have set it up exactly like that, set it up with a child to help them manage their affairs, but had 4 children. And then one of the children, or the person died, everything went to that 1 child, effectively writing out the other 3. Now, in that instance, that 1 child felt the responsibility to go ahead and distribute the assets among the siblings, but that child didn't have to do that legally. They could have kept all the assets. So you need to make sure that when you own something with someone, how it is set up to make sure how it passes. Another instance in which things might not pass according to your will are beneficiary designations. So you would see this on, let's say, insurance policies or retirement accounts. Whenever you have an insurance policy or retirement account, sometimes annuities fall into this, or even investment accounts, money markets, those sort of things. Oftentimes you'll designate what's called a pay on death beneficiary. And that is the person who gets that asset upon your death. Just like our previous scenarios that we discussed regarding ownership, in those scenarios, you end up with that asset going to whoever the pay on death beneficiary is, not necessarily going according to the terms of your will. So if you want to make sure that the terms of your will are followed, you need to make sure that your beneficiary designations and your ownership actually match what your desires are, and then also have the will. So another thing that a will does not do is it does not avoid probate. So what is probate? Probate is the process by which the person that is designating your will, usually called an executor or sometimes a personal representative, distributes your assets upon your death. And so let's walk through a scenario, right? You have a will and you pass. And let's say this will leaves everything to your wife. So in this case, the wife here is your official wife as opposed to your unofficial wife. And so let's say your official wife goes down to the title company and says, the ranch that we owned or that my husband owned goes to me via the will. Title company, you need to make sure that the deed is in my name. And so title company says, sure, deed's in your name, official wife. And then all of a sudden, unofficial wife pops up and goes to the title company and says, whoa, 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 wait, no, I'm actually the wife here. Or maybe a third person shows up with a will that's different from the will that the official wife showed the title company. As you can see, very quickly, you're putting the title company in a position to make decisions and determinations that it's not really set up to make. So that's not how our system is set up. Our system is set up that the court makes those decisions on the front end using a probate, that then the executor or personal representative can take those documents to title companies, banks, other institutions, and those institutions have some assurance that it's the correct will, it's the correct wife, it's the correct executor who's making these decisions. So that's why you have probate, and that's why when you have a will, you have to have it probated through the court and made official before anyone will work with you. So what do I mean by taking it to the court and making it official? That process usually requires an application to the court, a hearing at the court in which you prove up that the will is the final will and testament of the deceased, and then prove that you were supposed to be named the executor in there. And then the court issues an order on what are called letters testamentary that you can then take to banks, financial institutions, and the like to transfer assets. Now, so a will, going back to that for just a second, a will does not avoid probate, right? There are ways to avoid probate, one of them being trusts, which we'll talk about a little bit more in the next installment of this series. But a will within itself does not. So the last area that I want to talk about, the will doesn't, or another area that a will doesn't help you with, is as you age. So sometimes there's this misconception that a will gives your executor the authority to manage your affairs while you're still alive. And a will doesn't do that. A will only comes into effect upon your death. So I thought this was a cute little cartoon. The don't flirt with death thing was just made up by my wife. But the point of that is that your will does not take effect until you're actually passed. So what sort of documents can help you as you age? Those would be powers of attorney. They can help with your medical. They can help with your financial. You can also sometimes do a trust. But those documents can help appoint people to help you manage your affairs as you age. You can't rely on your will for those. And again, that's also a series that we will go over later on. So having gone through what wills do and don't do and some of the misconceptions, I want to walk you through some basic provisions that all wills really should have in them. Some of these are Texas specific, just so you know, for anyone who may have a will from another state. That's something that comes up quite often in my practice, is someone who has lived somewhere previously and has a will from another state. Most of the times wills from another state will work, but sometimes there's a few state different provisions that can make them a little more cumbersome. And so anyway, this is drafted, or these examples are drafted from a Texas perspective. So the first thing most wills have is they state who the person is that's making the will. In this case, it's John Doe. And then it also says that any prior wills are revoked. And this is important because people will often make more than one will over their lifetime. And in fact, should be looking at their estate plan every time there's a major life change or every few years, because life really just does change. And so these documents aren't really one and done. They do need to be updated on occasion. When they're updated, you want to make sure that any prior wills have been revoked. If you don't do that, then you could start getting into a construction area where you say, all right, well, which will is binding, which heir gets what. So that's why typically at the very front end of your will, you'll see that any prior wills are revoked. The second thing that a will should have is your family information. Probably 90 to 95% of the estate planning I do involves everything to my spouse, and if my spouse should predecease me, everything to my kids, or everything to my kids. This is the section that tells the court and the people who are working with your executor who your spouse and kids are. Now, if you're leaving stuff to I also see a lot of leaving to nieces and nephews or other relatives. This is also the area where you describe who those people are. So you could imagine a situation if this was not in a will, and you had a will that said everything to my children. And then you take that will to the court to be probated, and the court's going to say, well, that's fine and dandy, but I have no idea who your children are, right? You then have to have another proceeding in the court just to have the court make legal orders to who your kids are. So it's really important that you have this family information or information on your heirs in your will, so you don't have to make court determinations on the back end who you're leaving items to. The next thing that most wills have are, well, all wills have where your assets are going to go or your estate is going to go upon your death. There are two basic categories of giving stuff to people. One is a specific category and one is a general category. So right here on the screen, what you're seeing is a specific distribution. And I like to use the example of the great-grandmother's gravy boat when I talk to clients about this, because it seems like every family has that heirloom that everyone wants, right? It's always kind of the weird thing too, like a Homer Simpson statue or a gravy boat that all the kids are going to fight over. But that's what a specific distribution is when you are giving a specific piece of property to a specific person. And so I'm using the example here of small items that families tend to have, but this could also be a piece of real property. This could be a set amount of money. I want to give $100 to my daughter, something like that. But it's a very specific sort of distribution. Then typically what's next is your residue. So people often ask me, what the heck is this residue of my estate? So if you think of your estate as a big basket of your assets, right? And so these are the assets that have not gone by beneficiary designation. And then you take out of that basket your specific gifts. So in our previous example, we take out of that basket the Homer Simpson statue, and we take out of the basket the gravy boat. Everything else that's left in that basket is your residue. And so that can include money, property, cars, everything that you own that hasn't otherwise been given away in some other way. And so this residue is then described as who receives it. And oftentimes, like I said, it'll be something like my spouse, and if my spouse predeceases me, to my descendants. And then there's language that'll say like per stirpes. So let's talk about both the term descendants real quick and per stirpes. So descendants is defined by anyone who comes from you. So kids, grandkids, great-grandkids, those are your descendants. It does not include the spouses of your children, and it doesn't include your ancestors. It's just the people that come after you who are from you. Per stirpes is a way of dividing things. And so there are a couple of different categories on how you divide things. And so there's per stirpes, there's by representation. Long story short, what that language says is how the stuff will be divided if one of your descendants are gone. Per stirpes tends to be the most common one. And what that says is, let's say you have 3 kids and each kid has 2 kids. You've got 6 grandkids and 3 children. And unfortunately, let's say one of your 3 dies before you. If you have in your will that I give it all to my descendants per stirpes, what that means is that residue is going to be divided 3 ways, 1 share for each child, and then your 2 children who are still alive will get their share, and then your 2 grandchildren that are from the deceased child will get that share. And so they'll share that 1/6 each. Now, like I said, per stirpes is just one of the ways it can be divided up. There are other ones that get quite complicated, but that's something to discuss with whoever is drafting your will, how you want that to work if someone should predecease you. And then there's always an alternate disposition in a will. So us attorneys, we like to be almost tedious about trying to cover every possibility that may happen. And so I often call this the meteorite provision, right? So or asteroid provision. You're on a family vacation with all your kids and grandkids, and the asteroid hits you and you're all gone. There's no one left. You have no spouse, no kids, no grandkids. Who gets this stuff? And so oftentimes there'll be a provision in the will that says, if all of the people that I've named in this will have died before I do, or died at the same time I did, then I want it to pass according to the laws of the state that I live in. After the gifts are made in your will, then there's the naming of an executor. So most people have an idea of what an executor is. This is the person who is charged with getting all of your assets, paying any final debts, and then distributing those assets to whoever you've named in your will. You'll see here that we only have 1 executor named, and this is actually a bad idea. You want to have more than 1 executor named. Oftentimes, things don't go as we plan. So we often plan that we'll go first and then our children and then our grandchildren, but sometimes that's not how it happens. And so sometimes your executor that you've named here may pass before you do. If you don't have a backup, the process through which a new executor has to be appointed is more cumbersome. So you always want to name a successor at the same time that you name your executor. Wills typically have a provision in there that allows the executor to serve without bond. So many states, through their probate code, require the executors post a bond. And that's to make sure that they properly distribute the assets and pay the creditors. However, you can circumvent that via the will. And so oftentimes wills try to make it as easy on their executors as possible, and they'll have a provision here that waives any bond. You also usually see provisions in a will that allow for informal probate proceedings. What that means is there are probate proceedings that are both formal and informal. And as you can imagine, formal tends to be more cumbersome and more expensive. So oftentimes you want to allow the executor to do an informal proceeding, which tends to be easier and a lot cheaper on your executor. Also, a lot of times people allow their executor to get a small fee for doing this. Being an executor can take a lot of time and energy. And while a lot of people will do it for no pay, most wills allow the executor to get a small fee for handling the affairs. Some wills will have what are called contest provisions in them. And so these are provisions that say if someone attempts to fight my will, then they don't get anything. So if you have a particularly contentious family, it's not a bad provision to have in there. I will tell you on the back end, they really are hard to enforce, but you still see them in quite a few wills. And then finally, you'll see survivorship presumptions. This is intended to take the case where two people die in close succession to each other. So for example, maybe you were in a car wreck with your daughter and you pass first and then 3 days later your daughter passes. This provision helps determine whose will things are going to pass under and who is deemed to have lived or survived the person who passed, or your will. And then finally, in your will, or all wills, to be properly authenticated, need 2 witnesses and a notary to sign them. If you do not have 2 witnesses and a notary, a will can still be probated, however, it is much more difficult. So just know that self-proving affidavits, those also help in the proving of the will for purposes of probate. So again, if you're missing those witnesses or the notary, the will either won't allow to be probated or may be probated and it'll be more difficult. So you want to make sure that those provisions are in there. I think I misspoke earlier. I said it still can be probated. Sometimes it can, sometimes it can't. So just know that. So those are the provisions that all wills should have. So what happens if you have an outdated will or a do-it-yourself will? What are some of the pitfalls there? So let's start with outdated documents. So you'll see on the provisions I had shown before, your witnesses here are long-lost neighbor and elderly friend. Sometimes when you go to probate a will, you need to have those witnesses come and testify as to the authenticity of the will. And if you had the will done 30 years ago when you lived in another city, another state, or we've even had one where someone lived in Canada like 30 years ago and we've had to try to track down witnesses from Canada, finding that long-lost neighbor or finding that elderly friend to show up in Texas or a Texas court to give testimony or to do what's called depositions on written questions to provide that testimony to the court can be really cumbersome and can really prohibit your ability to probate the will. So one of the initial dangers of having outdated documents is if you need to call on those witnesses, they can be really difficult to find. Additionally, outdated documents can be a problem as your life changes. So let's take the example of this family. Let's say mom and dad came in, got a will and a springing trust because they want to protect their kids in the case of their early demise. And then they don't do anything. And all of a sudden, this is that family 30 years later. And so the provisions that were in that will to care for young children probably are not the same provisions that you need to care for an adult child. In addition, a lot of times what you'll see when people make wills for children, as their executor, they'll name maybe a sister or a brother or an aunt or an uncle. And then when they wait 30 years, those people are either gone or deceased, or maybe they're not as close as they once were. And so you want to be updating your executors and your wills periodically, because otherwise this information gets stale and you may not have the best people in there to help effectuate your will. So let's take another example. So again, let's take the family that came in, did it right, did their will while their kids were young, and then life happened. So life can happen in a number of ways. There can be a divorce. Maybe a kid grows up and has some judgment issues or some creditor issues. Maybe even you have another kid, right? All of these things can really affect what happens with your will. As your kids age, if they've got judgment or creditor issues, you may not want a will, you may want a trust instead. Or if you end up getting a divorce, you may not want your spouse to get everything. Just so you know, there are some backup provisions in Texas that prevent that result if you do get divorced, but those are also cumbersome and something you have to effectuate through the court, which make it more difficult. And then finally, in the case of the afterborn child after a will, if you don't have language in your will that includes afterborn children, then you have to rely on state statute for that child to get anything. So again, just some pitfalls that can happen when you let stuff get outdated. What about the do-it-yourself? So again, I keep coming back to the self-proving affidavit and the witnesses, because these are so important in terms of how easy it is to probate a will. And if these are wrong or not done right, it can make it so much harder on your executor than it needs to be. And this is an area where in do-it-yourself, it's really easy to mess up, to not have a will signed with the proper language and the proper witnesses and notarization, which then means just more court time for your executor. Another thing we see in the do-it-yourself category quite a bit is someone decides they don't want to give that gift anymore to that child, or maybe they want to add something to their will. So they take their will, they'll cross through a provision, they'll initial it, and then they leave it. Problem is those handwritten notations aren't effective. A handwritten notation like that has to be signed with the same formalities as a will, meaning it has to be notarized and witnessed for it to be effective. So you may think you're changing your will, but you're really not. If you want to change your will, it's really best to do either a codicil or just do a whole new will. I tend to encourage whole new wills because codicils can get very confusing very easily. Another area in the do-it-yourself that you see is the entirely written yourself will. And so a will that is entirely in your handwriting can be valid. A will that is partly typewritten and then signed by you without the formalities may not be valid and may not be able to be probated. Additionally, when you're doing it yourself, this one that I have on the screen actually has quite a few of those provisions that we talked about earlier that should be in your will, but oftentimes people don't know that those provisions really need to be there, and handwritten wills will leave that out, which then makes probate, again, difficult and cumbersome. And finally, the thing that do-it-yourself tends to, or the problems I tend to see with the do-it-yourself is there's no contingency plan. There's no backup executor if your executor is to pass first. There's no, if a child passes first, what happens to what I was going to give to them? And when you don't have those backups or those contingency plans set out in your will, then state law takes over, and that may not be what you had intended or wanted. And then finally, just a short note about legal forms. You know, everyone's familiar with the forms you can get off the internet. Some of those are pretty good for state-specific forms. Some aren't. The biggest problem I see with those is the formality execution. Sometimes they're not notarized and witnessed like they should be. Sometimes they're missing the Texas-specific language for things like an informal probate, which is important, or to be able to sell some assets for the executor. And then third, they oftentimes won't have contingency language. Again, if my son or daughter predeceases me, what happens? Also with the forms, a lot of people run into the problem we talked about initially about beneficiaries and co-ownership. They'll think, again, I've drafted this will, it takes care of everything, where the beneficiary designations or co-ownership may be sending assets a different direction. So finally, I run into this, oops, sorry, just almost pulled down my earphones here. I run into this one occasionally, and this is, I really don't have much, I don't need a will. And so if you have any assets, if you have any money sitting around, if you have a bank account, which most people do, if you have a car, if you have a house or own any real estate, you really do need a will. While the bank account may pass according to an ownership designation, if you are the only one on that bank account, once you pass, if you do not have a will, that bank account will go according to state law to whoever the state law says it goes to. And you have to have someone go to a court and apply again to be a personal representative of your state just to get that bank account out. At the end of the day, that can be really costly and spend any of the money left in the bank account. Same thing with houses and cars. So really, on the front end, it is so much cheaper to spend the money to have a will drafted than to leave, even if they're small assets, to leave them without a will and then have state law take over. So, and we're getting into this category. What happens if I don't have a will or if my will has problems? Ultimately, it means on the back end, your heirs are going to spend more money just to settle your affairs. They're going to spend more time in court. They're going to spend more time just trying to figure things out. And all of that is not only time consuming, but it's also costly. So probates take time. And when you don't have a will guiding the probate, it can take much longer. And sometimes those people you love are waiting on those assets for whatever purpose, right? Maybe they need them to live off of. And sometimes when it's taking a long time for them to get to those assets, it can be problematic. I wanted to throw this up here because this is an example of what happens under Texas law if you do not have a will, or if your will does not dispose of all your property. So let's say you have a will and disposes of most of your property, but not all of it. Anything that your will does not dispose of will go according to Texas law. And this is what this graphic shows. I'm not going to go through this graphic because I think just looking at it, you can begin to get an idea of how complicated it gets if you don't have a will. It's because Texas is a community property state, that's complication number one. Then if you add in any other complications like you're married with children, or you're married to someone but your children aren't from that person, all of that begins to really complicate who gets what. And as you can see, this process is a lot more cumbersome than having a will that just lays out, here is what I want to happen. So this is what happens if your will is not effective or you don't have one. And so this is also what happens if your will is not effective or you don't have one. I get a lot of people say, I'll be dead, I don't care. But this is how your heirs and your loved ones are going to feel having to take care of this stuff afterwards. And I really encourage people, and I get it, who wants to think about this, right? Who wants to necessarily deal with any of this? But your will, in a lot of respects, is your last statement to your loved ones. And once you are passed, you can't change that. So what I have seen on the back end is that people who don't have a will, or who haven't told their heirs what's in their will, those heirs afterwards can end up very hurt and very upset because they don't know why you did things the way you did it. And they can be left with a mess if you don't have a will. And so at that point, you can't explain to them why you did it, did things the way you did, and you can't comfort them because you're not there. So I really advocate that clients not only take the time to at least do a will, but also to talk to your family and your loved ones about what is in there. It is an uncomfortable conversation for sure, but at least on the front end, you can address some of those emotions. And on the back end, the heirs tend to be a lot more receptive to what happened if they know what's going to happen on the front end. And so this is the result that we want to lead to, is that, you know, at the end, mom, dad, whoever is gone, loved us, we love them, they had a great life, and we don't have a lot to deal with, or at least it's not as big of a mess as it could have been. So that is a lot of information on wills to throw into a short amount of time. I am going to stop the recording. We had a couple of people come in after we started. So you know I've been recording this so that the library can put it up on their YouTube channel once we are complete. But I am going to stop the recording here in just a moment so that people can ask questions. I'll unmute at that point as well. And just to let you know, if you came in late, this is the first part of a 5-part series. We will go further into trusts, powers of attorney, beneficiary designations, and probates in the later series. I'm aiming to do one a month with the library. We haven't set the next one up, so probably sometime in late October, but make sure and watch the library emails for those next dates. And I appreciate you all attending. And if you'll hang on, if you have questions, just hang on for one moment and I will unmute you.